So this next panel will be our last panel before lunch. So after this session, please go out and pick up a box lunch and join us back in the ballroom for the final two sessions of the Institute. So our next panel will discuss SEC enforcement and investigations and discuss recent enforcement initiatives, including cybersecurity, ESG, financial reporting enforcement, and other hot topics. The session chair for this panel was supposed to be Arian June, who's a partner at Debevoise & Plimpton. Yesterday morning, she woke up not feeling well, and so we had to make a quick change, and I'm so happy to announce that Joan McCown of Jones Day will be chairing this panel. I think, Joan, you chaired this panel last year as well.
Yeah.
Many of you, I'm sure, know Joan. She is a more than 30-year veteran of the SEC's Division of Enforcement. She spent many years there as the chief counsel of the division and now practices with Jones Day in their securities litigation and SEC enforcement practice, as well as their investigations and white-collar defense practice group. So, Joan, over to you. Thank you.
Thanks so much, Tom. And I'll briefly introduce the rest of the panel. Next to me is Andy Geist. Andy is a partner at O'Melveny. And I should say, all of us practice in the same space. We all do SEC enforcement defense work. We do counseling as well. But primarily, we're the people that you have to go to if you haven't listened to all the good advice, or your client hasn't listened to all the good advice that you've been hearing the last couple days, and Kabir and his team have come and spoken to you. We're the lawyers that practice in that area, along with Dixie Johnson, one of the co-chairs of the program. So we do SEC enforcement defense. But as I said, next to me is Andy Geist. He's a partner at O'Melveny. And a few years before that, he was on staff at the SEC doing enforcement work up in the New York office of the SEC. Next to Andy is Brooke Clarkson, and Brooke is a partner at Foley Lardner, and where she is a rising star. And next to Brooke is Jane Norberg, who is a partner at Arnold & Porter, and prior to that, she was the head of the Office of the Whistleblower. And so, obviously, we'll have some really interesting things to say about that later on. We're so sorry that Arian couldn't be here this year, but she has us well prepped for this program. So, Jane, we'll start with you. This is obviously, and it was very helpful to have Dixie do the survey this morning, and we took note of what your interests are and that sort of thing, and are gauging what we're speaking about to that. But cybersecurity and Reg SID. Cybersecurity is something that affects everybody. It doesn't matter what industry you're in. And but before we talk more broadly about it, there have been some interesting cases involving Reg SID in the past year, and they were followed by an exam alert that talked about it. But what are some of the issues that companies could be focused on to avoid scrutiny in that area? And then maybe we'll get into cybersecurity more broadly.
Sure. And for those of you who are unaware of it, so Reg SID is sometimes known as the Identity Theft Red Flags Rule, and it applies to certain SEC-regulated entities such as financial institutions and creditors under the Fair Credit Reporting Act, who maintain certain types of accounts. And under that rule, they're required to establish a program that will detect, prevent, and mitigate identity theft with respect to those covered accounts. And the program, in a nutshell, is supposed to be appropriately sized and tailored to that specific business needs. And so, as Joan mentioned, the Division of Exams issued an alert with respect to some things they were seeing in the exam space under Reg SID, some deficiencies they were seeing. And it's interesting because, as you all know, when the Division of Exams issues an alert, usually there are cases that will be following it. And so for 2023, I actually expect to see more cases in this particular space. But actually preceding it, there were 3 cases that were brought in July And under those 3 cases, there are some highlights that I thought would be really helpful for everyone here, even if you're not subject to Reg SID. So in at least one instance, the program that was put in place to identify these red flags, these theft red flags, the program was very generic in its language, and it was not specifically tailored to that particular firm. So for example, they simply restated the general legal requirement, and I'm going to quote this, identify red flags and, quote, respond appropriately to any red flags, which of course is as generic as you can get, and it wasn't specific at all and didn't give specific examples for what that firm may have been seeing and real instructions to their employees as to how they could respond if in fact they did see a red flag in order to mitigate possible identity theft for their customers. And in another matter, the board of directors of that particular firm had not been appropriately overseeing the red flags program, and so getting the board involved was also a problem that this particular firm was facing. One interesting thing that I would point out is that none of the orders pointed to actual theft that occurred because of the deficiencies, but rather the orders just found that the firms failed to maintain an adequate program. So in a nutshell, some key takeaways from these cases are, say, if you're subject to Reg SID, is number 1, making sure you have a program that's well thought out and sufficiently tailored to cover your particular business. Number 2, make sure your board approves it and has oversight of that program, including getting regular reports as what's being seen under that program. And 3rd, just training your employees on the program and making sure they know how to handle issues if they do see any red flags underneath that program.
Very interesting, Jane. And taking it even a step more broad, what I heard you talk about is generic disclosure. SEC hates that. I call it fraud by grammatical error. If you use may and something's happened, right? And so we'll talk a bit about that. But generic disclosure, they hate it. Nobody, though, wants to go into gory details on these things, so it's a real challenge. And then also controls. I think I heard you really talking about having appropriate controls in place. So taking that resources and crypto, cybersecurity does impact everybody. What are you seeing in that space?
Yeah, so I would say at the SEC specifically, I'm sure all of you saw that the Division of Enforcement did increase its staff in the newly named crypto assets and cyber unit to put in 20 new people into that unit, which doubled the size of that unit, which in my view, as someone who was at the SEC, it's hard to get like 1 or 2 resources for your team. So putting 20 people in one unit is honestly like unheard of. So they're definitely gearing up for that space. Now I will say, I feel like all the headlines lately are about crypto, which makes total sense given what's happening out there in the crypto space. But don't forget about the second piece of that title, right? It's the crypto assets and cyber unit. And so I do think that a lot of those resources will also go to looking at potential cybersecurity breaches.
And I think that's probably where it will affect a lot of the people in this audience too, based on Dixie's poll earlier, is that, crypto is one of those things I think garners a lot of headlines, but maybe doesn't hit home for everyone. I think cybersecurity does.
Yeah,
I can't think of any firm or any industry that doesn't touch.
No, it does touch everyone because we're all connected. I agree, Brooke. It is broadly. So what you're hearing is, Kabir talked earlier today about taking note of the cases that they bring, but Jane talked about the exam alert, and they have all kinds of alerts for investors and that sort of thing. Tells you where they're looking. Staffing, those of us who have been on staff know, as you said, Jane, getting 2 staff members is a big deal. So 20, so they're, this is criminology at a certain level, but reading the tea leaves, they look very, very interested in that. So they had, as everybody in this room knows, an ambitious regulatory agenda. but what have we seen from an enforcement standpoint that would be instructive?
Yeah, so I would point to an example of a type of case that we might see again. Is a case that was actually brought a couple years ago against an educational publisher for misleading statements and omissions related to a data breach, and then also having inadequate disclosure controls and procedures in place. And so in that case, student information, really PII, was stolen through the data breach. And a couple of things got the company in trouble with the SEC here. So in an SEC filing after the breach, the company referred to the data breach as a hypothetical risk, when in fact it knew the breach had already occurred. And that's to Joan's point earlier, the SEC hates broad hypotheticals, especially if you know something very specific and material happened to your business. If you don't say it in the disclosures, that can definitely trip up a company. They also noted that they had strict protections in place to prevent breaches, but in fact, they failed to patch a vulnerability after it had been identified. So again, having like these broad statements, and I know Brooke might talk about this in the ESG space, right? These broad statements about things that your company is doing and how good certain measures are or procedures are or company culture or whatever it may be, making very broad statements when there are things that the commission can point to as gaps can be problematic. And then also similar misstatements and omissions were made in media statements as well as their SEC filings. And then finally, the order found that the disclosure controls and procedures were not designed to ensure that those responsible for making those disclosures were informed of the circumstances surrounding the breach. And so I would say a couple of takeaways about this case is that it really, I think, illustrates the need for strong controls around disclosures. And I like to think about it as having like sort of a cross-functional team, right? Of course, legal is involved, of course, compliance is involved. But when you're talking about very specific instances, like perhaps having someone from your cybersecurity reviewing some of the disclosures or business people to ensure that there's accuracy in what's being said, and then making sure that those controls are going to all the statements. As I'm sure Brooke is going to talk about in the ESG space, the material misstatements and omissions can be anywhere, not just the SEC filings. It can be on your web pages, it can be in media statements, it can be in press calls, it can be in verbal statements. So really making sure that those controls are very broad and covering everything that's being said with respect to a particular issue is really important.
Yeah.
Yeah, and one other thing I would say, so when it comes to cyber, the SEC really seems to focus in two primary areas. One is disclosure, the other is insider trading. And there have been cases over the last few years or investigations over the last few years where companies have had some type of cyber incident, some type of breach. It can be the result of a phishing attack where people's mailbox rules are changed, and there are inquiries about who has had access to people in sensitive positions, emails, and they're looking at that from a trading perspective. And so there's a real benefit to keeping an eye out for that, making sure that you've got controls in place that are designed to detect potential breaches, to train your people to be alert. I know at our own firm we have periodic simulated phishing attacks, just so that if and when you have an issue, one, you can identify it early, have it get escalated to the right people timely so that you can remediate it promptly, and if you have a problem with the SEC, you can advocate all that you've tried to do to remain compliant. With this group being combination crypto and cyber, you can avoid crypto just by not investing in that space. Cyber, you just by existing, right, they're coming at you all day, every day, and you've got to make sure you've got processes in place to defend yourself and then be prepared to defend yourself in case you have a regulatory inquiry.
What I think is interesting, though, is kind of the shift a little bit in, I think, what we used to think of more as cyber intrusions, where, and this is similar to the case you mentioned, where like, information is taken or something is, there is a breach and a negative impact as a result of that breach. But I think now in some of these disclosure cases too, the breach itself, even if nothing is missing or no customer information was taken or there's, no harm, no foul kind of, the thought is, well, there is harm because they were able to at least penetrate some layer of your security, and that's kind of indicative of a greater problem.
Yeah, I'm hoping that over time the SEC will become a little more sensitive and aware of the fact that practically every company gets breached every day. And so, I don't think there has been that understanding. I think hopefully they're going to start seeing that.
And what's truly material? What's really material that should
That's
be
right.
disclosed?
That's right.
The complicated piece.
That's
Not
right.
every breach is created
Exactly.
equal.
Yeah, that's right.
And how do the companies themselves assess whether a breach is material and who's involved in that process? And again, thinking about that in advance is always a good practice.
That's right. Well, listen, let's, we only have so much time, so we could talk the whole time about cyber, but we won't. The next thing that obviously has been on the SEC's agenda front and forward is ESG, which we were talking about in forward-looking statements. So, Brooke, the SEC brought some cases this year. Now, I think when we were talking earlier, maybe some of those cases would have been brought anyway, but now they're ESG cases. But what lessons can this audience learn from some of those initial cases?
Yeah, well, I think you're exactly right. I mean, the ESG task force was set up in 2020, in the spring of 2021. And this past year, we've seen kind of, that task force kind of, bear some fruit. But the question is, are these actually cases that are directly linked to that task force, or are they just kind of have an ESG angle? And I think the latter is probably the case. I think a few of these are a little bit unique and a little bit more within the wheelhouse of what the task force was really meant to do, what the purpose of the task force was. But a lot of these cases kind of boil down to just, more traditional fraud. And I think, from there, the overarching message is that, the SEC is taking a broad approach, and they are going to tag, anything with an ESG angle as within the purview of this task force. I think, you can see that by the industries and the, entities that are involved. And, the cases that were most recently highlighted, there's a couple of investment advisors, a couple of mining companies, a health insurance distributor. I mean, it's not industry or entity specific. I think it's also not surprising that so far the focus has been on the E in the ESG. That's garnered most of the headlines and most of the attention and most of the resources. But we'll talk about one of these cases later. The S and the G shouldn't be overlooked. The SEC is looking into that as well. Investors are clamoring for information about that as well. And so even though the E is kind of top of mind, it's a three-letter acronym, and they're all important. I think two of the cases that I thought that were more interesting and more kind of in the wheelhouse of the task force were the BNY Mellon case from May 2022 and the Goldman case from November 2022. And there you have, for those who aren't as familiar, in the BNY Mellon case, it was material misstatements and omissions regarding how ESG principles were informing investment decisions. They kind of looked at two funds. One of them had more strict policies and procedures regarding how that was done. The other one didn't, and I think there was some line blurring between what was being said about one versus the other. In Goldman Sachs, it was more of a failure to adopt and implement policies and procedures that were governing the ESG factors that were being assessed. So they said they have an ESG framework that they're using, but what is that framework? The framework wasn't developed until after some of those investments were made. And then once that framework was developed, it wasn't being consistently applied. And so, I think, those are more of the types of cases that the task force is and kind of should be focused on. I think we're seeing kind of a broad brush, though, because ESG is a hot topic, so it is where there are resources. I think one thing that's interesting, though, is that we don't have final rules, especially regarding the climate change. We have proposed rules, but no final rules. So all of these cases are still being brought under pre-existing
Well, that's
rules
right.
and historical
Kind of
climate
raises the
action.
question of do they need the new rules, but okay.
Well, I think
yeah.
it exactly begs the question. And in there was the press release for the fiscal year 2022 kind of enforcement results, and in that they attributed these cases to, and I'm going to read it, the time-tested principles of materiality, accuracy of disclosures, and fiduciary duty, which I think is exactly that question, and I think is what some of the commissioners have said, is that it's not that this isn't an important issue, but the question is, do we need additional layers of rules and regulations? The counter is, well, that provides some sort of consistency into an area that is very inconsistent in terms of what's being reported, excuse me, and how information is being assessed. But I think since all of these cases are being brought anyways.
Yeah, they are being brought anyways. And, I think one of the concerns is, when you have a broad set of rules that people can understand and see how they get applied in different industries, basically the rules that are already in place, if you start having special rules for what I'll call the fraud du jour or the issue du jour, you can get loaded up on a lot of very specific things. And you're always going to be playing catch up as a regulator, so very interesting. Brooke, you've done a great job of saying, and I think a lot of people initially thought that this was all about like investment funds that label themselves as green and weren't fully disclosing. You pointed out that it goes way beyond that. Also, what about the social aspect, the Wahid Invest case? What messages does that case have for this audience?
Sure, that was an interesting case. So that was a February 22 case, and for those that don't know, it's an internet-based registered investment advisor, and unlike most investment advisors that were touting the ESG or the E focus of the ESG, this RIA marketed itself as purchasing only Islamic law compliant securities and having an income purification process for the investments. And what I think is interesting about that is, when I think of the E and the ESG, and the proposed rules, there seem to be a lot more, distinct, metrics and measurements. What was interesting to me about this case is that, the issue was that they failed to adopt written policies and procedures regarding how they were going to go about making sure they were in compliance with these investments were in compliance with Islamic law, both in the present but also going forward, and how they were going to kind of calculate and report on the purification of income. And so, to me, it's these the investment strategies, even for these more subjective goals or more subjective targets, still need to be backed up with specific policies and procedures. It's not a, well, I know it when I see it type of approach. And I think that's what it was, is that it was, well, we generally know what falls into this bucket. And the SEC was saying, well, that's not good enough. You can't just generally know what falls into the bucket. You're saying you're doing these things. We want the specific process and procedures that you are implementing to make sure that this is what you say it is. And another interesting thing about that case, I thought, was also the focus on kind of going forward. So it wasn't that these policies and procedures end once the investment is made. If you were claiming that you are doing this, you need to have ongoing policies and procedures and things that are going to periodically check and recheck to make sure that what you said is still what exists.
Absolutely. And, we've talked a bit already about policies and procedures. Critical to have, to the SEC, remember, if it's not in writing, it doesn't exist. It's important to have them written down, obviously, but also to have them, Andy, to be something that you can actually live up to, because you're going to be, any thoughts on that, any pearls of wisdom there?
Yeah, so you get in trouble if you don't have a policy and you're supposed to have one. But you also get in trouble if you have a policy that you don't follow. And there are too many times where companies will have a policy that's not either tailor-made to the way they do business, or it doesn't really think about how the business operates day to day. And in many respects, you're better off not having a policy than having a policy that you don't follow. And regulators hate that.
And Kabir mentioned this morning about people that don't follow their policies. Go ahead.
Correct. So you need to think holistically about these things and make sure that what you're adopting works day to day, making sure that you're training people about what the policy is, what the expectations are, what the procedures are, and then again having controls to make sure that people are actually following the procedures. And if you can try to incorporate those compliance aspects of your procedures into the day-to-day business operations so that it becomes almost second nature, that's a worthy thing to have. And then periodically reviewing what your policies and procedures are. Are they still accomplishing what you intended them to achieve? Do they need to be adjusted? Companies grow, business practices change, not necessarily dramatically, but incrementally. And it's important that, if your policy says, we consider these 3 things, and now you're considering 5 things, or if the policy says we consider 5 things, and now you're considering 3 things, you got to make sure that you're saying what you do and doing what you said you're going to do.
Yeah, and if we sound a little defensive, it's because we are defense counsel. But one thing you should think about is when you have policies and procedures, think about if the SEC came to me and said, prove that you did this, prove that you followed this, what would you have? So many times our clients have said, well, yeah, it was our policy. Of course we followed it. We would talk about it at this meeting. Well, do you have agenda notes? Do you have do you have an agenda? Do you have meeting notes? Did you do this by email? Just remember, if it's not in writing, it doesn't exist. And to Andy's point, you need to constantly be updating and thinking about your procedures.
Well, it's like the old mantra, though, right? It's a show your work.
Yeah.
I mean, if you're, to Andy's point as well, make sure you have policies and procedures. Make sure you're doing what they say. Make sure you have controls in place to check those policies and procedures. Make sure they're written down. Make sure that the right people know about them. I mean, that was one of the issues as well in the BNY Mellon case, is that, the certain people in compliance didn't have all the information they needed to make sure
Right.
that the disclosures were accurate. So you want to make sure that the right people know what the policies and procedures are, and that to the extent that they're changing, people know that they've been changed. Because I think sometimes it's an information lag that can get people in trouble as well. I also think we talked about this a little bit, but I think it relates to this as well in terms of don't overstate what you're doing. You don't need the gold standard. Say what you are doing, but also don't try to unnecessarily couch it. Don't use permissive language when you know that that's not accurate. Don't use the mays, the mights, if that is not what you're doing. If you are doing something, don't say you may do it. If you're not doing something, don't say you might do it.
I call it the dreaded may. The SEC is going to jump all over may in every area. So
I think terminology is also important, though. I mean, one thing we're seeing in this space is that ESG means a lot of different things to a lot of different people. And so, I think if you can be clear in your terminology, you will do yourself a favor, because there's less, in one way you have a little bit less, wiggle room, but, you're also creating less of a, ambiguity in what you're saying, or what someone's interpretation is of what you're saying.
yeah. Brooke, where do you see things? Where do you see things headed regarding ESG enforcement?
Yeah, I think, obviously there'll still be a focus on the E. As I said, I think the S and the G are going to gain more traction. I think some of the, areas that we've seen or will see are kind of like executive comp, political contributions. I think some of these things that are kind of hot button issues that now can get roped into some of this, ESG mindset and framework are going to be what people look at. There's another case that's kind of percolating, which is the Activation Blizzard case, where that one's more, an SEC investigation regarding employment and other issues, and there's sexual harassment type of claims, and so that's kind of getting looped into this too. Whether that's more the social or the government's, I leave it to other people to decide, but it falls into that rubric.
Right, and there's not a case that's been brought there, but we've
No,
heard in the press about an investigation. Right,
Exactly,
the
and I'm sure
company's
there.
disclosed.
Yeah, and I'm
Yeah.
sure there are others probably that are, in the works in these areas, because there's obviously
Yeah.
always things that we don't know about until they're, front page news.
Mm-hmm.
I also think, and this was something, we were talking about in one of our prep sessions, is, you have a lot of companies that over the past few years have made a lot of aggressive statements, and I think, they led with their chin a little bit, and I think that they're vulnerable for some of the things that they said regarding, in particular, kind of the net zero strategies. I mean, that's something that Commissioner Crenshaw has mentioned in several of her speeches, that, time and again, you hear companies targeting this, net zero proposal, but what does that mean? How are they going to get there? How are they going to measure it when they do get there? And so I think the SEC is going to be looking at, not just what you're saying today, but what you said a few years ago.
Right.
To see, as that, clock is ticking and you're getting closer to whatever pledge you made, are you actually achieving it?
No, that's right, the forward-looking statements. Some of this ties into sort of the next frontier. I mean, Brooke mentioned the harassment cases and that sort of thing. Jane, I think Dixie raised the McDonald's case regarding executive actions and that, and it's where employment law and the securities laws intersect, and there's what's maybe the right thing to do from an employment law standpoint, but then there's disclosure. But a fascinating case. I think we could all talk about this one forever, but do you have some thoughts regarding that?
Yeah. So, and I know that Dixie touched on this a little bit this morning, so I'm not going to go into huge detail about it. But if you haven't seen the order in the McDonald's case, take a look at it because it's really interesting. But McDonald's basically terminated its then CEO based on a relationship that the CEO had with an employee that violated their policies, and McDonald's disclosed in a press release, and then in the 8K also attached that press release what they knew at the time of that departure, and that was that the CEO had a single relationship in violation of company policy, right? So that wasn't hidden, it was put out there. Now, where the issue comes in, and this is something that Grabir spoke about this morning, that in its proxy statement, they noted that they were terminating the CEO without cause, right, which called then for the vesting of certain stock option grants. And the proxy statement did not note, though, that the company was exercising its discretion to terminate without cause, when in fact, the CEO's actions could have been a for-cause termination underneath their plans. And so it's interesting because, again, I feel like the McDonald's did say that they were terminating him because of this violation of policy, but they just failed to say that we were exercising our discretion to allow for the vesting of these stock options by deeming it, quote, without cause. So what happens next, which will tie in a little bit to whistleblowing, is that after the CEO gets paid this very lucrative severance package, an additional tip came in internally to the company, I assume through an internal whistleblower, through a whistleblower hotline, saying that in fact there were a lot of other relationships that the CEO was having, not just this one. And the company did an investigation and sure enough found out that that was true, and actually took a really critical step in suing the former CEO in court to actually recover what they had paid out to him based on that without cause termination, which I thought was a pretty extraordinary step by the company to do that. So it's interesting. I think the takeaway is to Joan's point, is that it really is this intersection between employment law, right, and the negotiations that happen behind the scenes between the company and the lawyers for the CEO of this company, and how are we going to couch this, and how is it going to be like a nice departure and everyone's happy, and not making it a for cause, but then you have their disclosure obligations to investors, and I think what I heard Grabir say this morning is that it's material, right? He was getting tons of money, right? Tons of stock options that were vesting, And investors weren't informed of it. They weren't informed that that was a discretionary waiver. And so I think that it's just an interesting case and something to really be thinking about as these things might be playing out behind the scenes when you have somebody in the C-suite who may have violated company policy, and you're faced with these disclosure obligations while still trying to negotiate behind the scenes the employment issues.
Very challenging.
One of the things, though, I think that makes that interesting and a little different, though, is I think there were allegations as well that the CEO had lied during
Yes.
his, during the internal investigation questioning, and so I think they had a little bit more to go on than just companies made a decision. To use its discretion, and that there was also that element of it that I think just leaves a bad taste in people's mouth, and so made this a case that I think otherwise could have been, a little bit of a head scratcher.
Yeah, no, that's right. But I don't think the company knew
No.
that he lied
Yeah.
at the time of the disclosure.
didn't.
Yeah, it happened
Yeah, at
later.
the time of the
Yeah.
disclosure.
Yeah.
No, and so it's interesting. You never want to be a person who makes yourself interesting to the enforcement division,
Yeah.
Right.
and so just a little tip there, and so
Some inside baseball.
and so doing this sort of thing obviously is going to get people interested. One thing, and I think you need to look no further than FTX in terms of making yourself interesting, but we're not going to go there. So, Jane, or anyone on the panel, one thing that was interesting about the case is it was McDonald's disclosure, but they sued the individual CEO as well. Again, I think he'd made himself kind of an attractive target, but although they don't have targets. But thoughts about him. So you're the person, they're putting out a press release for you, and sometimes this happens. We represent individuals, and the companies put out a press release regarding you, and they haven't quite gotten it right, maybe. Now here we do have the overlay. But say we didn't have the overlay that he had lied, although it's fine if you want to go that way. But so he reviewed, he saw, he maybe didn't write the company's press release, but he gets sued for the disclosure that was made. Any thoughts about that, or is it inextricably intertwined with the fact he lied?
Yeah, I think in my view, it kind of is intertwined with the fact they lied, at least in this case, right? Because they did put this in front of him, he did review it, he had the opportunity to correct it, that it was a single relationship, and he didn't. And he knew otherwise, obviously, and just lied during the internal investigation. So I do think it is intertwined when it comes to this particular situation. It's really hard to imagine a situation. I guess maybe there could be a situation, but it would be a scary situation, right, where someone reviews it and then they are, even after the fact, charged because of the disclosure issue. If it wasn't something sort of so blatant, right? It feels so blatant, right? Yeah. That's what makes it, I think, made it attractive to the SEC.
Right. Well, let's move on. Financial reporting enforcement, obviously of interest to this group. The EPS initiative, Brooke, seems to continue to bear fruit. And one of the things that maybe the people in the audience have heard about, but certainly everyone should be aware of, is data analytics by the SEC. Started out with insider trading, but it was so successful there, they have tried to replicate that everywhere. And earnings per share initiative is one of the things. Do you think it has been a game changer in enforcement of financial reporting cases?
So I don't think it's been a game changer just for the fact that it's really not new. I think, the staff has brought these types of cases that they brought under the EPS initiative, these kind of slightly more, quantitatively immaterial kind of adjustments. They've brought those in the past. I think what this does, though, is it just allows them to a lot more effectively and efficiently identify patterns and trends. And so I think it's just, it's another tool in the tool belt. I don't think it will change their enforcement approach, but I do think it will, change the speed and the ability to identify some of these issues sooner rather than later. And I think that's, for this audience as well, is kind of, there's the difficulty of, paying attention to your data, but also the optics of your data for that reason. And, understanding that, sometimes they're, subjective accounting judgments, and we've talked about this before, is document it. Like, the best thing that you can do in these types of cases is make sure that when you're questioned later, you have something to point to and say, this was the reason we did this. It was not because we were gonna, we were a penny shy of earnings and we just decided to put our thumb on the scale. There was a, legitimate reason, it was discussed and it was vetted. Because I think too often, sometimes, that's what it comes back to is, well, why did you do this? Well, there was a legitimate reason. Prove it. And then to your point, if it's not in the documentation, it doesn't exist. What I think will be a challenge is kind of what is responsible earnings management versus what is inappropriate earnings management. Because there are legitimate reasons for, certain things, but and ultimately I think, documentation is probably where you're going to save yourself because, I think that to say that any of these kind of, immaterial, quantitative adjustments, can get on the SEC's radar. What you want to do is get off that radar quickly, and the ability to do that is kind of based on how you've positioned yourself and documented what you're deciding to do.
Yeah. So taking that and data analytics and sort of trends in the financial reporting space, yesterday, of course, at this conference, there was a lot of discussion about non-GAAP financial measures. What impact are you thinking will have in the enforcement space from the CorpFin updated guidance?
Yeah, so I actually don't think the guidance is that surprising. I think it's pretty much reflecting what we've already been seeing in the comment process and enforcement actions. And so to me, it's not, it's almost like the EPS initiative, is that it's interesting and it's of note, but I don't think it's really a sea change or all of that, all that different from what we've already been seeing. The guidance kind of focused on non-GAAP measures with certain characteristics being viewed as misleading potentially, and the presence of or presenting kind of non-GAAP and GAAP measures with equal, or the GAAP measures with greater prominence. But again, none of that I think is what we haven't already seen borne out in the enforcement actions. So to the extent that it's interesting, it's almost just like an exclamation point on what I think the staff is trying to say is, if you didn't get it from what we were doing, here is more. Here's the and then here's the guidance to go with it to say that this is what we're expecting.
That's right, and this is, and it is sort of regular way to have the guidance. Then, like Jane talked about with the Reg SID, usually you have the guidance and then you have the cases, and so certainly guidance usually is based on something they're seeing that they want to update, and certainly enforcement and the rulemaking parts work together. So we have to think, I mean, it's something that they've been talking about, as you say, Brooke, for a number of years. So again, with all that's happening in the world, supply chain, everything, pandemic, what are some of the traps that companies need to be aware of when approaching their MD&A disclosure?
Yeah, I mean, unfortunately, I think there are a lot of traps that you could fall into.
Right, and there was the recent NVIDIA case, and so.
Yeah, I mean, and some of this is what we've already kind of said, and is kind of being echoed, is, be careful what you say. You don't necessarily have to always speak, but if you do, it better be accurate and complete. And make sure that what you're saying actually comports with what you're doing or expected to do. I mean, I think, again, people sometimes get a little optimistic in some of their disclosures. And while that is, great in terms of your goals, that is not great in terms of disclosure. You want it to be measured and balanced and based on what you have already done or what you can reasonably do in the time frame that you've set forth. And so I think a lot of people get in trouble when the disclosures that are making an MD&A are grounded more in your future prospects or your optimistic outlook on things, and not in what you're realistically seeing. And I think supply chain is one of those ones where we've seen people get in trouble.
That's right. That's right. So slightly switching gears, you know, Kabir talked about remedies earlier today. Remedies are extremely important once you get sucked into the enforcement orbit, if I'll call it that. And we did see, Andy, this is your cue to somehow get your slides up.
Okay. I have to figure out how to do that.
Yeah. Oh, there we go. Okay, there we go. So anyway, that was giving you a minute. So, but anyway, so the SOX 304 clawback is something that has been of real interest to the last year. We saw a lot more of it. I mean, it's always been hanging out there, but we seem to have seen more. Why don't you give folks some pointers in that area?
Sure, and you know, as John mentioned, Kabir mentioned it in this his talk this morning. SOX 304 was adopted in the wake of the major accounting scandals, you know, around the turn of the century, I guess we can say, it is designed to hold CEOs and CFOs accountable for events at their company. And when it is triggered, the CEO and CFO must return certain compensation that they receive. And the triggering events are, one, the issuer is required, and we'll talk about what required means, to prepare an accounting restatement due to the issuer's material noncompliance with a financial reporting requirement as a result of misconduct. And we'll talk about what constitutes misconduct and whose misconduct in a bit. So once you have those series of events, the CEO and CFO must return any bonuses they receive. Doesn't have to be tied to the financial performance that was related to the misstatement. It's all bonuses, all incentive-based compensation, all equity-based compensation that they receive in the 12 months after the first filing or public issuance of the financial statement that ends up being restated later, and then any profits from their sale of the issuer securities during that same 12-month period. And the SEC, and only the SEC, has the ability to excuse them from their obligation to make that reimbursement. Required does not mean that the SEC has ordered you to do a restatement. It arises when the issuer is compelled, and that could be by facts and circumstances. It could be because your auditor will quit if you don't do it. That constitutes being compelled. But there also has to be an actual restatement filed. The Shanahan case involved a situation where there was no restatement, and the SEC said, well, there should have been one, and they tried to get 304, and the court said no. And as I mentioned, there are cases that hold that the SEC does not need to issue an order to you to make the restatement in order for the clawback to be required. Whose conduct? Anyone at the company. It's not just the CEO and CFO. And in the original days, the SEC was bringing cases only against CEOs and CFOs that were engaged in substantive wrongdoing. But they began to seek clawbacks against CEOs and CFOs who were not themselves charged with any misconduct or even aware that there was anything improper in the financial reporting. And there's this interesting quote, we heard a little bit of it this morning, where it talks about this prevents people from profiting from the proceeds of misconduct, whether it's theirs or someone else's. But the statute goes beyond that, right? So if there was a restatement because revenue was overstated, and the CEO and CFO received a bonus because they had worked at the company for 50 years or because they had successfully completed an M&A transaction, that bonus is subject to clawback, even though it's not the proceeds of misconduct. So it's a very broad, draconian remedy that's available. Misconduct itself remains undefined. The Ninth Circuit had the opportunity to provide some guidance about what is and what is not misconduct that triggers the clawback obligation. And the majority declined to do it. Judge Bea thought that guidance should be provided and thought that it was either an intentional violation of law or gap on the part of an issuer. But again, this is not the law. This is just, the view of one judge. And so as you're going through and dealing with a situation where there's a restatement, you have to make the decision of whether or not there's misconduct. And there are circumstances, and many of us have been involved in them, at least on the defense side, where there's an internal investigation that's done. The internal investigation concludes that there was no misconduct. There's a restatement, there's an SEC investigation that follows, and the SEC reaches a different opinion. And then, at least increasingly these days, the SEC will come to the former CFO or CEO and say, oh, well, you're aware that this was this restatement, and we've determined that there's misconduct, and so now you have to pay back all this compensation that you received. Even though the company had concluded that there was no misconduct and there's no suggestion that the individuals themselves were engaged in any wrongdoing.
One of the challenges, Andy, is when the company's making a decision as to whether to restate, and say the current CEO and CFO were, there during the time. It presents a challenge in terms of making that decision, because, well, we know from the poll earlier that you all are not as interested in individuals. This is a relevant and important point to consider from a corporate governance standpoint about making that decision.
Sure, because they have a vested interest in the outcome. And that's also one of the interesting aspects of the new exchange rule, which provides a broader range of clawbacks, where it's not triggered from the date when they actually decided to restate. It's triggered by when they reasonably should have made the decision to restate. And that new exchange rule is broader and narrower, so it covers a broader group of people. It covers essentially your Section 16 officers.
So it's not just CEO and CFO.
Right, not just CEO, CFO. But as they mentioned this morning, it's more delta-based. So it's recovery of the compensation that represents what you received versus what you would have received under the restated financials. SOX 304, as I mentioned, covers all bonuses, regardless of what they were awarded for. Under new 10D1, those time of service awards, special awards for completing an M&A transaction are not covered by that. And so you could have a situation where, there's a differential between, the amount of recoveries.
Well, and that's having some ripple effect in the corporate world as well. I mean, I know we're the enforcement panel, so we should stick to the enforcement panel, but we're getting a lot of questions from colleagues, especially executive comp colleagues,
Right.
about how am I going to structure this now? Like, we're not saying that there's going to be an issue, but if I'm, working on the pay package of a CEO who thinks, yeah, it's great to have all these built-in incentives, but 5 years from now, if someone down the chain that I don't really know does something that I'm not involved in, and it's not related to what this is, I don't want it that way.
Right.
Right.
And yeah, it's a great point. There's a real premium on thinking as you're adopting policies and procedures to comply with the new rule of how you're going to execute it if and when, hopefully it doesn't occur, but if it does, and so how you can clearly understand what's subject to it, how can you assure collectability or take steps to reasonably assure collectability? That may go into things like payouts. And then the other thing is many companies already have a clawback policy. And so do you need to have a single unified clawback policy? Do you have one that is just designed to comply with the new rule versus the existing ones, which were in many cases targeted from investor demands or in anticipation of the new rule? So it's going to take a lot of time and thought. And again, as we've said earlier, right, think about how this is going to play out in real life. Right? How do you identify what components of the compensation are covered by the new rule, which ones are not? Unlike 304, where the onus is on the executive to make the repayment, under the new rule, the onus is on the company to go out and seek repayment, and there are very limited exceptions to the requirement to go ahead and seek repayment. One of the ones that will likely be most relevant for folks is that there's a determination made by an appropriate body that recoupment is impractical because the amount of the recovery would be outweighed by the costs paid to third parties to try to recover. Third party is us. But all of those decisions will need to be documented.
One point, of course, is that, before you have your concluding
Yep.
remark, is that the new rule is directed rulemaking from Dodd-Frank.
Right.
Now, it shows that the fact that they finally are getting it done now shows the interest in executive compensation here. But this actually is not something that they just dreamed up on their own. This was directed.
Right. Although it probably doesn't hurt that, the chair of the SEC was on Senator Sarbanes'
It does
staff.
not hurt. No, it does not hurt. It does
Way
not hurt.
back when.
Yeah. So, Andy, I'm sorry. if
Sure,
I interrupted.
and then just quickly, only the SEC has the ability to enforce 304. That also means that they're the only ones who can grant the exemptions, and there have been instances where companies have tried to indemnify or forgive the 304 liability, and courts have said that's outside their control.
Right. They absolutely, just to reinforce that point, you cannot indemnify an individual for penalties, and you cannot indemnify them for this, because it would be a round trip of the money, basically.
Right,
Right.
right. And
Because this money, I don't know if we've actually mentioned that the clawback money goes back to the company,
Right.
not to the SEC or the U.S. Treasury.
correct. And then in connection with the new rule, you also cannot reimburse the executives for any insurance policies to protect them against future clawbacks. We have here just a number of cases that the SEC has brought this year alone in the 304 space. Something that's also relatively new this year. So in the past, if an executive would agree to return the money, needed some extra time or some runway, the SEC would mention that in the press release, and that would be the end of it. In some of these recent cases, executives who have agreed to repay are still receiving cease and desist orders, which creates collateral consequences for them, and not just bad publicity, but it can also give rise to disclosure issues and other real life consequences for folks.
No, that's right. Oh, wait, no,
Don't go yet.
Not yet, not
Okay,
yet.
now I have to go back.
Not yet,
Okay.
we'll go back, yeah. Wrong slide. Half hour to lunch. So anyway, but we'll make it go quickly. So Andy, more broadly, obviously 304 clawbacks affect individuals. I do remember being on staff and having companies come to me and say, the person is insisting on being indemnified. Can we just forget this? And of course, it's a commission policy. They want to get these clawbacks. But individuals more broadly, 2/3 of the SEC, when they count their cases, they have these standalone cases, and that's one of the most important metrics, because those are the cases that basically aren't collateral or a spinoff of something else. But 2/3 of them had an individual. I never met a commissioner yet that didn't want to sue individuals, but there seems to be do you think there's a greater emphasis now? What do you think?
Well, even when we were there, we were always the question of what about the individuals? And so I don't think the level of interest has changed. I also think the numbers may be skewed a bit, so that, like you can see on the slide here, the middle two bullets relate to the Synchronis case. And I think in that case there were 5 orders. Right, so there's,
we know how that works.
right. Whereas, they all could have been.
It could have been one.
Could have been one. So, there's a little bit of skewing there, but there really has been an uptick in the number of cases brought against individuals. It's an interesting dynamic. Individuals tend to be the ones who are more likely to litigate than companies. The commission has traditionally been mindful of resources and thinking about, whether a particular case is worth the resources in litigating. I think the current administration is more interested in taking on that burden, and are more willing to pursue the more technical marginal cases, and if it goes to trial, they'll be willing to go to trial.
In the case of individuals, I know that I've seen it myself recently under this administration. Wells notices going out to just a whole wide range of executives and trying to figure out, are they all going to be charged? Is it all going to go through? And then to your point about the litigation for an individual, in many instances, these people are kind of fighting for their professional lives, right? Because certain charges can come, bars can come with it, and it can really impact somebody, for their whole rest of their professional career. And so it makes sense that people might be litigating in those instances. And this particular administration seems very aggressive, in my opinion, from what I've seen, against individuals.
Yeah, a couple of rules of thumb. Number one, the commission's view is that entities don't act on their own, they act through individuals. That's why they're focused on individuals, to try to nip issues in the bud. And then also, if you're an individual, even if the commission doesn't seek an officer and director bar, even if they don't seek a 102E barring you from appearing or practicing before the commission, if you're the company controller and you've been sued for causing the company's internal control failures, the auditors aren't going to accept your certifications. So it's a backdoor officer and director bar in a way. That's right, Jane.
Yep.
It's a really good point. Andy, before we leave remedies, which is a huge part of what we all do, penalties. They blew the doors off, although it was really the off-channel communications cases that that blew the doors off on terms of penalties. Any thoughts? Sky's the limit?
Yeah, well, they signaled that we shouldn't expect another record-breaking year next year. Now, whether it's still higher than the previous ones. Penalties have always been controversial, right? So the premise originally was, well, we don't want people just to break the law. If they get caught, they just pay back their disgorgement and be in the position where they were had there been no violation. And so we need to make it cost something extra. And so that's when the penalty, statutes started to get added. But particularly in the public company context, there are very different philosophical views, right? So who's paying the penalty? The shareholders, right?
Right.
And if it's an accounting case, the shareholders perhaps bought in at a price that was higher than it would have been if the revenues were lower. And so they bought the stock too high, and now you're going to make them pay again. There are those who then think, well, but there needs to be a corporate deterrent, and eventually, we expect that the shareholders will hold management accountable, and some of these are new shareholders who bought later, and so they're more interested in creating the general deterrent, I think, is what we heard Gerbere say, is like, you other companies don't do this, you're going to pay a penalty, and you're going to pay a higher penalty than the people came before you. So I think, although we're not going to see, the $6 billion, this year, I think at least for the foreseeable future, we're in a much higher penalty environment. And again, this morning we heard Gerbere say, if companies do the right things, if they, go through extreme cooperation, self-report, right? You would like to say, thank you, no case. But what we heard this morning is you'll get a lower penalty, you may get reduced charges, you may get no penalty.
Well, and you may not get an independent compliance consultant.
Right.
But I think what's hard with that is we're also hearing that, precedent, which we usually rely on quite heavily, is maybe not as strong of a backstop. And so, you cooperate or you self-disclose or you do all these things, and now you have a lot less to point to say, so I should be treated similar to this group.
Right. I think that, I will say this, I had a recent experience where I said, okay, I know you guys don't look at comparables, but, and I wouldn't like go in, and I didn't argue comparables, but I was surprised that the answer I got was, oh, well, we do consider it. So I was a little surprised, but I know, Brooke, that we've all heard that. And we've heard the story that Gerbere gave, and I would not go in saying, here's where we fall
what
on
you did
the,
before.
on the,
You have to do it again,
And I know we're gonna talk about whistleblowers, but I just want to point out really quickly about it goes into sort of remediation and cooperation. And so when you're thinking about internal reporting, right, and your employees putting in an internal report, regardless of where it goes, to the hotline, through a web form, to their boss, just making sure that every report is followed up on by the appropriate people at the company, so that you can determine whether or not to do an internal investigation, to do all these good things that we're talking about up here around potentially correcting if there is a problem and documenting it and remediating. And then you have the ability to make that decision, do I self-report or don't I, or do I, and even if you choose not to, if that individual, because a lot of times whistleblowers will go to the SEC, right? So sometimes that pushes the decision whether or not to go in and self-report. But if that whistleblower goes into the SEC and the SEC comes knocking, you can say, okay, you know what, we did get that tip, we took it very seriously, here are all the things that we did, and we remediate it. And that goes a long way with the commission to when they're taking a look at potential penalties and remedies.
Yeah. No, I don't think there's a more challenging decision you can make than whether to self-report outside of the situation where you think there's a whistleblower. And remediation, all is not lost if you haven't self-reported. It is critical to try to minimize the bleeding, and remediation is the way to do it. Andy, so we saw the waivers. Okay, we had the Jay Clayton policy, which in my view was just writing out a best practice for everybody. And then now that policy has been put aside. Waivers have become very political. We saw recently a settlement with Barclays where they had been sued, I think it was 2017, and they were denied a waiver. And then the more recent case actually sort of spun off from that in terms of controls. What about waivers? So you're trying to resolve the matter with the SEC. If it involves fraud, there's going to be WIXI issues, safe harbor forward-looking statements, Reg D. What should you do?
So this is a very important issue, and if you're ever in the situation where you're going to settle an SEC case, you have to think about the collateral consequences. So there are disqualifications that arise from the entry of certain SEC settlements. So, for example, some give rise to WIXI, the well-known seasoned issuer exemption. That was the issue in the Barclays case. There are other losses of safe harbors for small offering exemptions, forward-looking statements. And so you need to be thinking, as you're getting close to the resolution, of what those collateral consequences are, and then begin to engage with the staff as a way to either avoid the imposition of, or avoid creating the waiver. So there are certain charges that give rise to disqualifications and others that don't. So they may be willing to engage with you about charging decisions. And then you can also engage with the relevant divisions to see if they will grant you a waiver. And as you've mentioned, over the last several years, it's become incredibly political. Where in the waiver, for those who aren't familiar, is the commission can waive the disqualification that arises from a particular settlement or grant an exemption, depending on which one you're talking about. And so you need to begin to engage with the relevant divisions. So, typically, Division of Corporation Finance for public companies, to see whether or not they would be supportive. Sometimes you'll get a read that, yes, they're supportive, and then you proceed. Sometimes you get a read that they're not going to be supportive, and to avoid the public embarrassment of having it be denied, people will withdraw their applications. But you need to be thinking about that. And then another practical point is I've represented a client who was subject to a WIXI ineligibility from one settlement, which was sort of in the heartland of what you would expect. And they had a subsidiary that was about to enter into a different settlement that would give rise to another WIXI ineligibility, extend their time period. And we started talking to CorpFin about whether they would tell us now whether they would give us a waiver for Part 2, and they said, we won't entertain this while you're ineligible for under Part 1.
Oh my, that's right. So it's not just the corporation, it's subs as well.
Yep.
Yeah. Oh wow, okay. We're going to go to whistleblowers next, Jane. And so whistleblowers are incredibly, they have become huge. You were the head of the office, so you know front and center what the issues are. There's been some recent 21F17, which you could maybe explain to everyone what that means in English, and what can you tell us about the SEC's ongoing approach with whistleblowers?
Yeah, so Rule 21F17 basically says that no one can take any action to impede someone from reporting a possible securities law violation to the commission. And you may have heard about this in the past because the commission has brought, I think it's 16 or 17 cases now against companies and individuals for, in many cases, having language in severance agreements that the SEC viewed as potentially impeding someone from reporting. So a lot of times it was what was, standard confidentiality provisions, but there is an actual carve-out that needs to go in most agreements now, and I hope everyone in the room is aware of that. And if you're not, talk to me after, and I'll explain to you what it is, because it's the easiest way to get yourself in trouble with the commission. But the most recent case, I just wanted to highlight briefly because it really expanded the cases under Rule 21F17. In this particular case, the SEC amended a complaint against the CEO of a company and settled with the chief technology officer of the same company for steps they took against a whistleblower after he had reported internally some possible securities law violations. And it was in the, and at the time, it was over a workplace dispute. So they were apparently going to move this person's, from what I can gather from the complaint, move this person's workspace, and this individual was very upset by that and had said, by the way, if you move my space, and I'm going to go out and I'm going to tell everybody about this financial fraud that's occurring at the company. And so they ultimately ended up cutting off this person's access to their IT system and locking them, out of the building, and then ultimately fired them. And so while that sounds all very extreme, I think there's a couple of takeaways from that particular case. And I would say, number one, don't ignore information from a disgruntled employee, right? So this person was in the middle of this workplace dispute over his workspace, but in fact was telling them then about a financial fraud. And a lot of times, right, people on the way out the door or in the middle of a dispute might raise an issue, and it's really easy to just say, you know what, they're just angry, they're just saying nonsense, it makes no sense. But in fact, a lot of times those are the people who have the best information. And so just making sure that that information goes and gets elevated to the right people to, again, do an investigation and potentially remediate is important. And I would also say exercise caution when shutting down computer and building access. Not saying that you can't do it, but just make sure that you have a, reasoned, documented, sound reasons for doing so, especially after someone reports internally, so it doesn't look retaliatory or in what feels like a little bit of a stretch, the SEC found that they impeded this person by doing that. And then, noting that actions as well as words, right, can bring impeding charges, because in this case it was just actions. It wasn't something written in an agreement, it wasn't a confidentiality provisions, it was just literally the actions of shutting down the computer access and locking this person out of the building after they reported internally.
Jane?
And so, yeah, I would, go ahead.
Is that, we actually end at noon?
Yes,
So
yes, so I would just say, so long story short, these are bread and butter cases, quote, of the SEC. And so I would just be very cautious around whistleblower protections because I just think it's a really critical thing that they're looking at right now.
It is. It's huge. So, wow, that's quite a end to the enforcement session. But we're going to take a short break. So please stop at the Crystal Continental Room to grab a boxed lunch and come back for the last two sessions. And we'll start back up at 12:15. And thank you so much.